Hello everyone. Welcome to this video on yet another important international tax and transfer pricing ruling. So today I'll be discussing an Australian full federal court judgment which was recently pronounced on 8th of March 2024 in the case of Singapore Telecom Australia Investments Private Limited versus Commissioner of Taxation. So this decision is important for taxpayers and TP professionals as it reinforces several key principles from the Australian transfer pricing cases such as Glencore and Chevron, which were released a couple of years back. So the dispute in this particular case, it relates to a $5.2 billion loan which was issued pursuant to a loan note issuance agreement entered into in 2002 by the Australian company to a non-resident related entity, Singapore Australia Investments, SAI in short. So the agreement was issued as part of deal consideration relating to the acquisition of shares in Singtel Optus. The dispute, it involved approximately $894 million of interest deductions relating to the years ending 31st March 2010, 11, 12, and 13. So 4 years in total. There was emphasis on the commercial rationale of the transaction and the way the benchmarking was done to establish the arm's length nature of the interest payments. And there was also a discussion around, there were few amendments. There were 3 amendments in the terms of the interest which was payable. So let us discuss this case. Now coming to the background, so Singapore Telecom Australia Investments, STIA in short, I'll be using STIA. So it entered into a loan note issuance agreement with SAI that was resident in Singapore. STAI and SAI were ultimately owned by the same company. The total amount of loan notes issued to the participant was approximately $5.2 billion for a term of 10 years. And this was as part of the acquisition agreement. So part was in terms of shares and part was by way of debt. Now this particular slide, it gives the facts in a picture form, so it is easier to understand. Now, the terms of the loan note, they were amended 3 times. So the first and the second amendments, they were retrospective, effective from the date of the loan note issuance agreement, which was originally entered into. The third amendment, it increased the interest rate and it changed the interest rate to a fixed rate of interest from a variable rate of interest. So the interest rate was increased to 13.2575%. As a result of the audit under the transfer pricing provisions, the tax authorities disallowed the interest deductions, which totaled to approximately $894 million in respect of 4 years. So in the view of the tax authorities, the terms agreed between the parties deviated from the arm's length principle. So the whole discussion revolved around whether the arrangement that these related parties have, are they commercially rational? Will an independent third party enter into similar terms of agreement, whether they will agree to the amendment in the rate of interest which has been undertaken in this particular case. Singapore Telecom Australia appealed to the federal court, which in a judgment which was published in December 2021, upheld the assessment. So the transfer pricing officer, the tax authority, had made an assessment and made an addition. So that was upheld by the federal court, and the appeal by STA was dismissed. Then an appeal was made to the full federal court, which in a judgment which has been recently published on 8th March 2024, also dismissed the appeal and upheld the previous decision, which had upheld the transfer pricing assessment. So let us discuss the main principles that are emerging from this judgment. So the tax authorities, they tested whether the conditions operated between the two enterprises, that is STAI and SAI, in their commercial or financial relations differed from those which might be expected to operate between independent enterprises dealing wholly independently with one another, and substantially reduced the interest claims of STAI for the tax years ending 31st March 2010, 11, 12, and 13. The primary judge had found that an independent party in the position of SAI would not have agreed to make the changes contained in the two interest rate amendments. The court found that the terms of the loan notes, such as those issued in the actual transaction, differed greatly from the terms of a typical debt capital markets bond issue. Further, the overall approach undertaken by STAI's model was fundamentally flawed. Hence, the primary judge ruled that independent parties would not have entered into amendments number 2 and 3 as they lacked commercial rationale. Now, the full court also concurred with the findings of the primary judge of the federal court. So the full court also rejected the contention of STAI that the amount of interest actually paid over the 10-year period was equal to or less than that which might be expected to have been paid between independent parties in similar circumstances over the same period, as the transfer pricing standard was required to be met on a tax year by tax year basis, and the commissioner had the discretion to adjust the interest for earlier years as well. Regarding the 2003 amendment, it was noted that the full federal court relied on the primary judge's finding that there did not appear to be any commercial rationale for the amendment, and that it had been implemented to avoid withholding tax. So it noted that it was consistent with applying the independent enterprises hypothesis, having regard to the circumstances of each enterprise, to impute that the creditor, that is SAI, would have required a parent guarantee for a $5.2 billion loan, which was not available in this particular case. So the key takeaways of this judgment are, especially in case of a transfer pricing, it is very important to prove the commercial rationality of a transaction. And to prove the commercial rationality, it becomes important, it becomes very pertinent to maintain adequate contemporaneous documentation. It is also important to note that commerciality is necessary not only at the time of the amendments, but also when arrangements were originally put in place. The outcome should ultimately make business sense, as independent entities would ultimately seek to protect their economic interests, and there could be a situation where independent entities may not have entered into such arrangements, having considered the options realistically available to them. Evidence collated contemporaneously when such arrangements are entered into will assist greatly in supporting the commercial rationale and overall outcome. So these principles of commercial rationale and contemporaneous evidence do not just apply to financial assistance transactions, but they're also relevant to any related party dealing from the even for, say, provision of services or goods or use of intangible property, etc. In fact, if we look at the OECD transfer pricing guidelines, they also discuss about commercial rationality, about considering options realistically available to the entity, whether an independent entity or a third party will enter into the arrangement that the related parties have entered into. And in case there is not an exact similar option which is available, then what is the best option realistically available should be looked at. So that's it for this video. Do write in, do put in your comments on if you're liking these update videos. And these case laws will really help you to increase your knowledge on international tax transfer pricing principles. They will also help you to prepare for ADIT, which is Advanced Diploma in International Tax, which is provided by Chartered Institute of Taxation, UK. So do subscribe to my channel if you're liking the content. Thank you.